Right now, in February 2026, the legal foundation of this province is being challenged on multiple fronts, and they all revolve around this one question. Who actually holds power over the land? If you own property, build housing, finance projects, or make policy in British Columbia, this is something that you should be paying close attention to. Because this isn't happening in theory. It's happening in court, in legislation, and in billion-dollar industrial zones. First, we're going to look at the gold rush, or rather the legal fight over who gets to stake a claim, which has just been escalated to the Supreme Court of Canada, so it's a big one. Then we're going to look at a really bizarre situation where the BC government is rewriting environmental law to block US-based tribes from having decision-making power in BC. And third, we're looking at a precedent-setting attempt to reopen the massive Cowichan land title case. It sounds like a random grab bag of headlines, but I promise you they're all chapters of the same story. These are not minor legal skirmishes, and this isn't just abstract rights we're talking about. It's potentially the future of the Canadian economy. Make sure you're staying up to date on this stuff and hit that subscribe button below. Okay, let's start with the minerals. I'm not going to get too deep into this one because I already did a video doing a full breakdown on the Mineral Tenure Act. So if you haven't seen that one, go watch it for the full legal context. But here's the short version. For decades, BC operated under what's called the free entry system. You log into a government website with a map of the province, you see a plot of land that looks good for minerals, you click a button and boom, you now hold the mineral rights to that plot. That is the system that was challenged, and in December of 2025, the two First Nation groups that challenged it won a massive victory. The court ruled that this whole automated system violates the government's constitutional duty to consult. So the court said fix it, and this looked like a real win for reconciliation. But here comes a twist. It's February 2026, and the NDP government, led by David Eby, have decided to appeal this decision. They're taking it to the Supreme Court of Canada. And this is where the politics get sticky, because on the surface, this looks awful. This is the government that passed DRIPA. They literally passed a law promising to align with UN standards. So why are they now going to go spend more money to fight a court ruling that tells them to do exactly that? And the government's answer to that essentially boils down to one word: confusion. Eby is arguing that the lower court's decision is creating legal chaos around DRIPA. They're afraid that every single law in BC, forestry, fisheries, highways, could be struck down overnight by judges because it doesn't perfectly align with the UN declaration yet. So they're basically saying, hey, let us fix the laws and legislature at our own pace. Don't force our hand in court. They want to control the speed of the change. But the Indigenous nations are not buying it. Chief Counselor Linda Ennis said there is no confusion. She argues that the uncertainty isn't coming from the court ruling. It's coming from the government's refusal to modernize these old systems quick enough. Her point is that you've had years to fix the Mineral Tenure Act. You didn't, the court forced you to, and now you're crying foul? They're seeing right through his typical empty words and promises. And it just highlights this massive tension between certainty for the economy and justice for the nations. The government wants to pause the justice part to save the certainty part. But as we're seeing, that just creates a different kind of uncertainty. If you're a mining company, do you want to invest in a province where basic rules are being rewritten by the courts every 6 months? From the outside, it starts to look like expand rights when it's symbolic and then resist when it becomes a structural issue. Okay, now let's pivot to the border, and to do that we need a crucial piece of context, which is a Supreme Court case from 2021. A US citizen, a member of a tribe in Washington state, he crosses the border into BC, hunts down an elk to feed his family, and he's charged with hunting without a license because he's an American. But he argued that his ancestors lived in BC long before Canada or the US even existed. They were pushed south by colonization, and the Supreme Court agreed with him. They ruled that Aboriginal peoples of Canada can include the modern-day successors of groups now based in the USA. Essentially, this says that the border does not erase Indigenous rights. And now, in 2026, we are seeing a practical collision of that ruling. US-based tribes, including the Southeast Alaska Indigenous Transboundary Commission, are demanding participation status in BC environmental assessments for projects like Escalated Creek because the watershed flows into Alaska. The tribes in Alaska are saying, hey, if something goes wrong with the water, it's not the people in BC who are affected, it's us. so we should have a say. But the BC government is currently rewriting the Environmental Assessment Act to block these US tribes from having real decision-making power. But we just said the Supreme Court ruled that they have rights. They have rights to be consulted. BC is drawing a very hard line on the decision-making. They're creating a two-tiered system. If you're a First Nation inside BC, you can be a participating Indigenous nation. That means you can conduct your own assessments, seek consensus, and you have a seat at the head table. And if you're a US tribe, you get the comment box. You can submit a letter, you can be consulted, but you don't get to drive the car. BC is arguing that we can't have entities outside of our borders deciding our domestic policy. And it isn't just the government saying this either. Some BC First Nations agree. Chief Clarence Louis of the Osoyoos Indian Band, he's a heavyweight in Indigenous leadership, and he's siding with the government on this one. Not because he loves the government, it's about sphere of influence. The priority must be the nations here, the ones who have to deal with the BC government every single day. If you open the door to US tribes having veto power, you dilute the power of the nations here. Okay, now let's get into the Richmond land claim. If you've been watching this channel, you already know I did a full deep dive on the Cowichan title case, so I'm not going to rehash the entire trial here. But here's what matters now. In August 2025, the court recognized Aboriginal title in favor of the Cowichan tribes over roughly 2 square kilometers of land in South Richmond. This was not Crown land, it was privately owned industrial land, owned by Montrose Properties. Montrose is a major landowner in that specific area of the land claim. We're not talking about a small vacant lot here. This land hosts massive distribution centers for Coca-Cola and Canadian Tire. It is an active commercial property with warehouses and operating infrastructure. Montrose argues that they were never formally notified that their land was the subject of a title declaration. So now, and this is very, very rare, the federal and provincial governments are asking the court to reopen the case to let Montrose Properties testify. They want a do-over. They're arguing that they were never notified that their private land was at stake and they were never party to the trial. Now that the ruling is out, they're saying, hey, this destroys the value of our asset and we never even got to defend ourselves. And the government is backing them because they are terrified of the precedent. In their submission, the government explicitly says private land is in their submission, the government explicitly says that private property is foundational to the economy. They're scared that if Aboriginal title can sit on top of private property, nobody knows what that means. They admitted in their own filings that uncertainty remains, which is polite legal speak for we have absolutely no idea how this works. And that's why this hearing that was scheduled for last week on February the 13th is so critical. Because if the court allows Montrose to reopen this case, it sets a precedent that every private landowner in a claim area needs to be involved in every land claim trial from now on, which would make these trials take forever. It would grind the entire system to a halt. But if they don't reopen it, well, then you have a major company operating on land that suddenly has a layer of Indigenous ownership with no clarity on the rules. It feels like the government is just scrambling in all three of these. The mining, the US tribes, the private property, they seem to be doing the exact same thing. They passed the laws, they signed the declarations, they took the credit for being progressive, but now that the reality is hitting the actual machinery of the economy, they're hitting the brakes hard. The government claims they're appealing these decisions to create certainty for the economy. They want clear rules so businesses will invest, but think about what they're actually doing. They're appealing court decisions, rewriting laws mid-game, and trying to reopen closed trials. It makes it look like the rules don't matter or that they can just change if the government loses. As of now, there is no decision from that Friday the 13th hearing. Typically, written responses on procedural matters like this can take several weeks to a few months, but the outcome of it really matters. Now, let's look back and zoom out nationally. I did a full video on the land claim case in New Brunswick, and if you've seen that video already, then you'll understand where I'm going with this. That case was even bigger geographically. It was over almost half of the entire province. Private landowners were initially excluded from portions of that litigation. The Court of Appeal stepped in and said you cannot affect private property rights without those owners being party to the case. So they were added back in, and ultimately that court went further and ruled that Aboriginal title cannot be granted over privately owned land. The court said that compensation from the Crown was the answer instead. So when you look at the Richmond case, it's not hard to see the parallel. Is Montrose trying to push BC to the same legal outcome that happened in New Brunswick? We won't know for sure and likely won't for a couple weeks. weeks. But the collision between private title and Aboriginal title is no longer hypothetical anymore. Okay, and now I'm going to be blunt here for a second. The NDP keeps positioning itself as progressive and rights expanding. They passed DRIPA promising to align with Indigenous rights, but then fight every single court ruling that actually give those rights teeth. And so you have to ask yourself, was the legislation meant to be a roadmap for real structural change? Or was it just a symbolic gesture that they used to get your vote? It's starting to become a pattern, and it's very concerning. On top of that, they just tabled a budget that's projecting a $13.3 billion deficit. This is not strategic governance, it's reactive. They're failing First Nations by expanding rights without building a coherent implementation framework. They're failing private landowners by allowing title uncertainty to linger unresolved. And they're failing the province by spending more and more money to fix their own mistakes. None of this produces stability or clarity, and none of this resolves the underlying constitutional tension. Ultimately, all of this is pointing to one destination, the Supreme Court of Canada. This will almost certainly need to be resolved nationally, and the Supreme Court of Canada timelines are not fast. It could be 2 to 4 years before we get a definitive answer on how Aboriginal title interacts with private land in Canada. 2 to 4 years of uncertainty and litigation, where governments, investors, First Nations, and landowners are all operating without a final rulebook. So the real question is not whether change is coming or not. It's whether British Columbia can function coherently while the highest court in the country decides what ownership actually means in modern Canada.